A federal judge has ordered the U.S. Department of Justice to release less redacted versions of several Jeffrey Epstein-related documents or explain why key details have been withheld. The ruling adds a new twist to the ongoing legal fight over the government's handling of the case files. While U.S. District Judge Emmet Sullivan has given the Justice Department a deadline till the 2nd of July to comply. The order came in response to a lawsuit filed by an independent journalist. It argues that the Trump administration did not fully comply with the Epstein Files Transparency Act. According to the court ruling, Judge Sullivan said that the government had likely failed to meet the law's transparency requirements. He also questioned whether the Justice Department had provided sufficient reasons for withholding portions of the documents from public view. Now, the records at the center of the dispute include 8 emails in which the names of either the sender or recipient were blacked out. They also feature a draft indictment of Epstein with the identities of potential co-conspirators blacked out. Another record is a 2019 email that refers to several alleged co-conspirators whose names were also withheld. Now, the ruling puts fresh focus on the Justice Department's broader release of the Epstein files. In January, the department said it had released millions of pages of documents under the transparency law. However, it also acknowledged that many records had been partially redacted to protect the victims' identities, personal information, and matters related to ongoing investigations. The latest order comes after months of questions over how the files have been handled. Since December, the government has released millions of pages, including emails, photographs, and law enforcement records linked to the federal investigations into Epstein and his death while in pretrial custody. The Justice Department had maintained that only around half of the nearly 6 million pages collected during the Epstein investigation were ultimately made public. According to the department, many of the remaining records are duplicates unrelated to Epstein or protected from disclosure under legal privilege. The court's latest order now requires the department to more clearly justify those decisions.